Good afternoon. My name is James Toll, and I am an attorney licensed to practice in New Jersey, New York, and the District of Columbia. My main office is in Hackensack, New Jersey, and I have satellite offices located in Livingston and Atlantic City, New Jersey. For the first 20 years of my career, which began in 1980, I focused primarily on representing the gaming industry in all different kinds of matters, but all in the area of defense, negligence, products liability, Dram Shop cases, and the like. In 2000, I came up to the main office of my law firm in Newark, New Jersey, where my practice again was focused on doing defense work, this time in the area of mass torts, where I represented pharmaceutical companies, Fortune 100 companies, and the like. Today, I'm going to be speaking to you on the area of expert witnesses. Now, when we talk about expert witnesses, we're talking about individuals who, according to the New Jersey rules of evidence, and my primary emphasis or focus in today's presentation is going to be on New Jersey law and the New Jersey rules of court, both of which I have handy here. But keep in mind that these rules and what I'm about to discuss with you have equal applicability to New York, to the District of Columbia, to any other jurisdiction where you may find yourself practicing. In my career, for example, I've been admitted pro hoc vice in courts ranging from the West Coast in California to Louisiana to the Midwest, and in fact I'm admitted in the Eastern District of Michigan, where I had argued a motion for summary judgment on behalf of a large medical device company. But what I want to focus in on is New Jersey practice, and the scope of today's presentation is going to be about whether or not, in the first instance, you should be taking the deposition of an expert witness. Assuming that the decision is made that you should take the deposition of the expert, the next question is, what do I do now? Now, the presentation, I believe, is helpful for not only young attorneys, first-timers, if you will, but also lawyers who've been practicing for any number of years. And what I have found in over 30 years of practice is that there are lawyers who are very good at taking all kinds of depositions, including depositions of experts, and lawyers who lack certain basic skills, which I hope to be able to impart to you throughout today's presentation. The first thing that you need to be familiar with, and it's something that as a certified civil trial attorney, which I am and have been for a number of years, that I learned was that the court rules and the New Jersey rules of evidence are key to being able to take an effective deposition, whether it be a deposition of a fact witness or the deposition of an expert witness for that matter. So the first thing that you need to know if you're planning on taking the deposition of an expert is what are the rules that apply to that expert witness and to the taking of that deposition. If you don't have a copy, I would seriously recommend and commend to your attention, and I don't get any money for this, that you buy a copy of the latest rules of evidence, whether it be New Jersey's rules of evidence or any other jurisdiction's rules of evidence. What you will find in New Jersey is that the numbering of the evidence rules are, for the most part, consistent and go along with the rules of the federal rules of evidence. So the first rule that I would commend to your attention that you read and understand is Rule 701. And Article 7 of the New Jersey Rules of Evidence deal with expert witnesses. When is a witness deemed or considered to be an expert? What is an expert's opinion based upon? That is, what is permissible versus what is not permissible. And for starters, look at Rule 701. 701 talks about opinion testimony of a lay witness. Now, you may be asking yourselves, well, if an opinion is being offered, doesn't that opinion have to come from the mouth of an expert, somebody who has been qualified by the court as an expert witness? And the short answer to that question is no. And Rule 701, which you can read for yourselves and which is part of the materials that go along with this presentation, talks about when a lay witness or fact witness can give expert testimony. One very classic or basic example is judging or approximating the speed of a vehicle in an automobile case. Most courts follow the New Jersey rule, which again follows the federal rule of evidence, that when it comes to lay witness testimony in the context of an automobile speed, an individual who is familiar with driving a car, who's familiar with observing other cars, is qualified to testify on the basis of the speed of the vehicle. Specifically, that form of opinion or inferences that may be drawn from that opinion may be admitted, provided A, it's rationally based on the perception of the witness. In other words, the witness can't simply pull out of thin air what he or she believes another vehicle may have been traveling at a particular speed. But if there's a rational basis behind the opinion, that opinion may come in. The second requirement, which is read in the conjunctive and, not the disjunctive or, is that will the opinion of the lay witness help the jury understand a key fact that is contested in the course of a case? So those are the only two requirements for a layperson to give expert testimony. Now, when you get beyond 701, you then get into the nitty-gritty of what is, for expert witness purposes, the key rules. 702, which again is part of the written materials, is perhaps one of the most important rules of evidence that you need to know before you make the decision whether or not you are going to take the deposition of the other side's expert witness. And I will discuss with you in a few moments what factors should go into the decision making as to whether or not you are going to be taking that deposition or not.
Please take a moment to write down lawline.com's first verification code. Lawline.com's first verification code is the word alien, all in lowercase, A-L-I-E-N, alien.
Don't immediately assume that if an expert is named, and New Jersey is one of the few jurisdictions where deposing the adverse party's expert is something that is done without leave of court. You don't need to make a special application as you do, for example, in Pennsylvania or in California or even in New York to depose an expert witness, the other side's expert. In New Jersey, it's done as a matter of course, provided that the decision's been made by the attorney that this is a deposition that I should be taking. Now, 702 deals with expert testimony. And it says in relevant part that if scientific, technical, or other specialized knowledge will assist the trier of fact, in other words, in most cases, the jury, to understand the evidence or to determine an issue in fact. And again, that's where we get back to the basic test, whether it be lay opinion testimony or expert. Is that opinion being offered by the expert going to help the jury in reaching its verdict? And if the answer to that is no, then that testimony is never going to be coming into court by way of expert opinion evidence. So the first element is that testimony going to be of assistance to the jury? The second element is the expert witness qualified to be an expert witness? And in many instances, there are proceedings, which I'll briefly mention in New Jersey. Like the federal rules, you're talking about what is a Rule 104 hearing. Now, that is a hearing outside the presence of a jury where the proponent of the expert, that is the lawyer who is looking to put that expert on the stand and to render expert opinions from that individual, gets to ask various questions of the expert so that the judge, again, outside the jury's presence, can make a determination if the expert is who he or she purports to be. Now, an expert can be qualified as such based upon education, based upon skill, based upon experience, or based upon training. So you can have, for example, an expert, and a classic example would be My Cousin Vinny. Now, I don't know how many of you may have seen the movie, but I have attended seminars where the presenter has used My Cousin Vinny, and whether it was just to have Marissa Tomei on the stand or not, shown before the audience, one may never know. But the point is that Marissa Tomei was qualified as an expert witness on the issue of tire treads and as to whether or not a particular vehicle's tires could have made the treads that were found at the scene of, in this case, a murder. I believe it was a homicide that took place, and Joe Pesci was, of course, representing the defendants, and he's calling as a witness and inartfully, but nonetheless qualifying his fiancée, Marissa Tomei, as an expert. And he was able to do it not based upon her formal education. She didn't go to Harvard. She didn't, as far as I could tell, go to any college. But she knew cars, and she knew tire treads, and she knew which tires went with which models of cars. So she was permitted by Fred Gwynn, Herman Munster, if you remember, to testify as an expert based upon her experience and based upon her skill. So Rule 702 is going to be the first rule you're going to look at to see whether or not this so-called expert is going to be permitted to testify or not. Now, the reason that I mention that is because, as I'll mention in a few moments and talk further, if you decide to take the deposition of an expert, you have to have certain goals in mind as to what it is that you intend to accomplish in the deposition. And if one of the things that you want to do is to establish that this so-called expert has no expertise in a particular area, if you don't know what 702 talks about, you're not going to be able to craft your questions to make the determination as to whether or not this particular person would qualify at a 104 hearing, which I'm dating myself now, but when I started practicing, it was called a Rule 8 hearing. When the New Jersey evidence rules were changed, perhaps some dozen years ago, they were changed to follow the rule numbering of the federal rules. So 104 became the successor to Rule 8. But when you establish the goals for your deposition taking of an expert, if you don't know Rule 702, you're wasting your time, and more importantly, you're wasting your client's money if you happen to be defending the action by going forward with the deposition. Now, in addition to 702, you have to be familiar with Rule 703. And 703 is perhaps the single most important evidence rule as it relates to the testimony of experts. And again, referring to the written materials, you'll have those available to you. 703 deals with what can an expert base his or her testimony on. And that is a rule that you should know cold, because that is where you're going to be getting most of your objections at the time of trial, and it's the single biggest area in which you are going to focus at the time of your deposition. Because what you are going to find out, or try to find out, from the purported expert witness is, we have your conclusions, we have your opinions. Now tell us, Dr. Smith or Mrs. Jones, what are those opinions based on? Now, if those opinions are based upon nothing more than a personal, subjective belief of the expert, those opinions will never see the light of day, provided the party who is objecting to those opinions raises the objection at the time of trial or even before by way of a motion in limine, which is simply Latin for at the threshold. And what you're going to be relying upon if you're making an application to the court to strike the testimony or preclude the testimony of the other side's expert is that the opinions upon which the expert bases, or the facts upon which the expert bases his opinions, are nothing more than purely subjective belief. I am, as an expert, for example, saying that such and such is my opinion, and I am basing it on the fact that I'm an expert. Well, no, that's not what the case law says, and more importantly, that's not what the evidence rules say. So 703 talks about the facts or data in a particular case upon which an expert bases his or her opinion, or inferences to be drawn from those opinions may be those perceived or made known to the expert at or before the hearing. That's very important, at or before the hearing. If it's in the context of a deposition that you want to know what all of these opinions are, that's where you're going to find out what each opinion is. And if the expert in New Jersey suddenly comes up with additional bases for an opinion that was heretofore not disclosed in deposition, if you choose to take the deposition, then the likelihood is the judge is going to cry foul, and that expert is not going to be permitted to testify. Now, the second aspect of Rule 703 is that this data that may be known to the expert at or before the hearing has to be of a type reasonably relied upon by the expert in his or her particular field. In other words, it's designed to eliminate what has been often referred to as junk science in the context of, for example, mass tort litigation, or products liability litigation, or class action litigation. If what the expert is talking about does not pass scientific muster, that testimony may be stricken. And depending upon what jurisdiction you are in, you, as the party who is trying to keep out this testimony, may be looking at making what's known as a Daubert, D-A-U-B-E-R-T challenge, which many jurisdictions rely upon, or a challenge based upon another U.S. Supreme Court case, Frye, F-R-Y-E. And I'm not going to belabor the point because that's not the subject matter for today's presentation. That can be for another day's presentation. But know Daubert and know Frye, and understand in the back of your mind that if you're going to take the deposition of the other side's expert, you want to keep these cases in the forefront of your thoughts. The other evidence rules that you need to know about are Rule 704, which again will be in the written materials. Now, law, unlike other particular areas, can be very, shall we say, unequal. There can be an inequality in the level of experience of the lawyers involved in a particular lawsuit. You could be someone who was admitted to practice law 2 years ago and may be taking your first deposition of an expert, or you could be someone who's been admitted to practice for 50 years and may either be taking or defending the deposition of an expert for your 555th time. Unlike, for example, situations that can be controlled where, for example, in a boxing match, you may not have Muhammad Ali go up against a Golden Gloves champion who's making his professional debut as a boxer. Because to do that would be Ali at his prime near suicide. That wouldn't happen. But in the law, it can and often does happen where there is this inequality between adversaries. Now, what I counsel young lawyers is you have to find a way in which you can level the playing field. Because if you are taking the deposition, whether it's an expert witness, whether it's a fact witness, whether it's a deposition in an automobile accident case, whether it's a medical malpractice case, whatever the facts underlying the case may be, that's not the important consequential issue. The issue is, how do you level the playing field? And folks, here's how you level the playing field. You get yourself a copy of the New Jersey Rules of Court. And again, it may seem like I'm hawking these books. Trust me, I'm not. If you don't know the rules as it relates to the taking of a deposition outlined in the New Jersey court rules, you are never going to be in a position to level that playing field. Now, in the written materials, I've outlined certain rules that you need to know. Rule 4:10-2 is the one rule which talks about the subject matter of discovery. What areas, for example, can you, as an attorney representing a party in a lawsuit, make inquiry of the other side? Well, 4:10-2 has various subparts or subdivisions in them, and it tells you what areas you can obtain discovery on. Know that rule, and know that in the event you are in a deposition and the other side is giving you a hard time, and believe it or not, lawyers may from time to time try and disrupt your cadence, your rhythm, your flow, whether it be in a deposition, whether it be in a direct examination at trial, whether it be in an opening or a closing at trial, even whether it be in arguing a motion, although that is a rare occurrence. But many times, the other side's lawyer is simply trying to rattle you. And if he or she knows that you can be rattled easily, trust me, they are going to be rattling you as often as they can, because it is in their best interests, in zealously representing the interests of their client, to do so. So how do you avoid that? Well, one way in which you avoid it is you look at Rule 4:14-2. And that's a rule that, again, I would commend to your attention, and I would also suggest that you know that rule cold. Why do I say that? I say that because if you've ever been in a deposition and you were the questioner and you're asking the deponent a question which you believe to be a very fair question, a very unambiguous question, a question which is perfectly legitimate, but your adversary suddenly says, objection. Well, in most instances, all that happens in New Jersey practice is that the objection is noted, and the attorney who makes the objection doesn't do anything further than say objection, and then the witness is asked to answer the question. Well, if you want to level the playing field, what you should be doing is saying, well, what's the basis for your objection? And I mentioned 4:14-2 as being the precursor to 4:14-3, which deals specifically with objections. Because if you don't know 4:14-2, which deals especially with noticing up depositions and areas in which you may be entitled to obtain information prior to the deposition, 4:14-3 never will come into play. Take a look at 4:14-3, subdivision C, because that deals with objections. And if you're the attorney that's asking the questions, whether it be of the expert or the lay witness, and you hear your adversary say objection, what you should be doing to set the stage very early on is to either pull out the rule book or know 4:14-3C almost verbatim, and then put the onus on the lawyer who just objected to your question, who probably did it to do either coach his client, which is impermissible, to say, I don't understand the question, or has done it to derail you as the questioner and rattle you. And that will, as I said before, happen. But if you let your adversary know that they can't pull one over on you because you know the rules as well, if not better than they do, that objecting will stop, and you will then be able to take an effective deposition of an expert witness. And you can set the tone early. Now, 4:14-3C says, no objection shall be made during the taking of a deposition except those addressed to the form of the question or to assert a privilege, a right to confidentiality, or a limitation pursuant to a previously entered court order. So let's eliminate from the discussion, right from the get-go, confidentiality orders, protective orders, privilege, whether it be attorney-client privilege, whether it be spousal privilege, whether it be priest-penitent privilege, whatever privileges that are enunciated in the New Jersey Rules of Evidence, let's put those aside. The one objection that should and must be made by the attorney defending the deposition is as to the form of the question. Now, what you should do as the person taking the deposition is to say, all right, sir or madam, you've raised the objection. Please tell me specifically what is it about the question, the way in which I phrased it, that you find objectionable? And how do I cure your objection? Now what you've done is you have taken your adversary, who may simply have wanted to rattle you, and now you've put the burden on him to come up with the reasoning why your question was objectionable. Trust me, you may get one or two instances in which you get a cogent, reasonable intelligent response to why the question was inappropriate or improper. But for the most part, that's not going to happen. And once you've established that you're not going to be railroaded by your adversary, now you've obtained control, which is the single most important aspect in the taking of any deposition, but most importantly in the deposition of an expert witness. Because the expert is going in thinking they know more about the subject matter than you do. And in many instances, they may. But you don't have to let on that you don't know enough to make sure that you remain in control. So if you're taking the deposition and you know this particular rule, let your adversary be put on the defensive and let him come up with the reasoning as to why the question is improper and ask him to cure it. How should I be asking that question then? And if he can't come up with a reason, that question is permissible and you're entitled to an answer. Now, the other part of the rule, which you should take advantage of, and what you may want to do, especially if the litigation has been contentious up to this point, that is, up to this point of taking this deposition, is to find out who the pretrial judge is on your case, easy enough to do, and make sure, have your secretary or you personally call that judge's chambers and let them know you're going to be taking a deposition on such and such a date. Will the judge be available on that date? And when you find out the answer is yes, don't be afraid to pick up the phone. In a very courteous, civil way, you advise your adversary, I think this is an issue that's important enough to get the judge involved. Take it from personal experience. Once you reach for that phone, in many instances, that lawyer who's been trying to derail you is going to suddenly back off. And now you've got your opportunity to take your effective deposition. Rule 4:14-7, I'm going to leave for you to take a look at. That's the rule which permits you to take depositions of experts. It establishes where the depositions are to be taken. It establishes who pays for what. The only thing I would add to that is if there cannot be an agreement between counsel as to the cost for the deposition, you can make an application to the court, and the court will set the actual cost for the deposition time to be charged by the expert. Understand one thing, superimposed on all of this is civility amongst lawyers. Understand what goes around comes around. And if you're going to be arguing over the cost of a deposition, understand that when your expert is seeking to be paid, the other side may do unto you what you have just done unto him. So keep that in mind. Rule 4:14-9 is another rule that you should know about, and that's a rule which deals with the subject of trial depositions, or in New Jersey referred to as the Bene Esse depositions. Know that rule and also understand that unlike Rule 4:14-3 dealing with objections, if you're taking a de Bene Esse deposition, which in New Jersey is encouraged, in many instances, if your expert is not available and you seek an adjournment, you may be told, well, did you take his de Bene Esse deposition, or asked by the judge? And if your answer is no, you may find yourself in a situation where you're forced to go forward in a trial setting without the benefit of having that expert, And in those situations, you may want to put your malpractice carrier on notice. So to avoid that, and avoid that potential at least, know 4:14-9. Also know, which I learned the hard way many years ago, is that if you are making an objection during a Bene Esse deposition, you have within 30 days from receipt of that transcript to file a formal application with the court setting forth your objection, the reasoning behind it, and it's handled as any other motion would be. Those are the court rules. Now let's talk for a few minutes about a knee-jerk response, which I alluded to a few moments ago. Excuse me. The other side has served you with an expert report, which in New Jersey is mandatory. There are exceptions, but for our purposes for discussion today, the other side serves you with an expert report. Let's even assume it's an economist report. You have an economic report. The knee-jerk response is, got to take that deposition, got to do it. Well, in the setting where I was working in a large law firm before going out on my own, I would ask the attorney who was planning on taking the deposition, I want you to give me 3 reasons why you're going to be taking the deposition of this economist. And very often I would be looking back at the proverbial deer caught in the headlights. I never got, or rarely got, an articulate, sufficient response to the question. They simply thought, well, if the other side produced an expert report, an economic report, for example, we've got to take the deposition. My response to that is, no, you don't necessarily have to. What you need to do, whether you're on the plaintiff side or on the defense side, is to be able to give either your general counsel, defendant, client, or even perhaps your plaintiff client, your reasoning as to why that deposition is going to be taken. Because ultimately, that client's going to be paying for that. If it's a plaintiff's case and you settle it or get a verdict that's turned into a judgment, it's going to come off as a cost. And on the other side, if it's a defense cost, well then you know that the general counsel and the corporation is going to be paying for it. So ask yourself, why am I taking this deposition? I look at it in 2 ways. You can either take what's known as a constructive deposition of an expert, or you can take a destructive deposition of an expert. Now, I would recommend for those of you who are just starting out and are finding or feeling your way, is to start taking constructive depositions. You want to know everything that the expert relied upon in formulating his or her opinions. You want to have an opportunity to review that expert's file, which is very important and in which you are entitled to review, because I can tell you that in 9 times out of 10, if you had asked for and received the quote file from the expert before the deposition and compared it to the file that you received right before the deposition started, the likelihood is the 2 are going to be glaringly different. So in a constructive deposition, you're going to be taking a look at the file, you're going to be asking questions regarding bases for opinions, you're going to be asking questions regarding whether or not all opinions are set forth in this particular report. And are there any other opinions that you intend to offer at the time of trial? Now, why are you doing that? You're doing that because under New Jersey law, what you're trying to establish is to box in or limit the expert to the, quote, 4 corners of his or her report, so that if at deposition he or she says, every opinion that I intend to offer up to this point in time is set forth in this report. Now, I may reserve the right, if I get additional information, to offer other opinions. But for the time being, these are all my opinions. If that's the situation, ask the follow-up question. I want you, Dr. Jones or Mrs. Smith, to make an agreement with me that in the event you intend to offer any additional opinions in this case, you're going to be providing those opinions to your lawyer, who in turn are going to be providing them to me. Otherwise, I'm going to assume I have every one of your opinions. That's key, because again, you're boxing them in and you've made an agreement with them. You also want to make sure that you maintain control over this particular expert. Now, the way in which you maintain control is through your cadence, is through your rhythm. And if you've already learned how to handle the objections, that cadence and rhythm is going to remain throughout the course of the deposition. You're the one asking the questions. You're the one doing it at your speed, at your leisure. You're the one who can write out the questions. The jury's not going to know that you were sitting there writing out a question. So if you want to load up a particular question in order to get a particular response, take your time and load up the question with whatever facts, whatever information you want contained in the question. The jury is not going to see that. Even if it's a video deposition, such as a Debeni essay, they're still not going to see it. All they're going to know is that you asked the question a particular way. Now, when you ask a question in a deposition, keep two things in mind. Number one, every question that you ask, you should be assuming that that question is going to be read to a jury or read by a judge in some format. So make sure that the question is straightforward, is unambiguous, is not subject to interpretation. Have it black and white, so that if you intend to read to the jury, for example, the deponent's answer to your question, the worst thing in the world that can happen is that you start reading the question to the jury, and you may be looking at the particular transcript, and you're looking at the jury, and you're reading it with all of the passion that Perry Mason may have delivered in his heyday. And then you get to the answer and you realize, oh boy, I could have asked that question a whole different way, because the way I asked it and the answer I got really makes no sense. Now you've got egg on your face may have turned red, and the jury can sense your uneasiness. So don't be afraid to write out the question. Now, the second point with regard to control, and I am not a big fan of outlines. I have been in situations where I have seen people with outlines that literally start off with, "Hello, my name is Joe Smith, and I represent the defendant Aerospace Engineering, Inc. I am going to be asking you a series of questions today." Talk about a robotic approach to a deposition. That's not how you gain control of a witness. There's nothing wrong with having a sketch, with having an outline which covers basic points. But if you're going to be having a script, then go into television or the movie business. Don't go into our business. Because under those circumstances, what you're going to end up having is a situation where the witness is going to be gaining control over you, which is the very last thing that you want to do. You want the witness to be on the defensive. And if the witness is on the offensive and you're on the defensive, you've lost the opportunity to get that back. The other problem with an outline is you don't use all of your senses. What do I mean by that? You don't listen to the answer That is a key rookie mistake. And it's not limited to young lawyers. I've seen my fair share of older attorneys make the same type of mistake. Listen to what you have just been told by the witness and follow up. If you are too busy with your head buried in your outline, you're not going to be getting anything through your ears from which you can formulate the next follow-up question. Avoid doing that. Make notes. I figured out a long time ago, I can do one of two things well. I can either take a deposition and have my court reporter take down verbatim everything said in the room and pay him or her the money required to do that, or I can take an inadequate deposition and have copious notes of meaningless testimony. If you can do both, more power to you. I haven't mastered that in almost 32 years of practice. What I'm suggesting to you is listen and follow up. The other thing about not relying upon an outline is the ability to establish rapport with that witness. You want that witness not necessarily to like you, but you want that witness to feel very much at ease. And whether it's throwing in a meaningless question, maybe even a quick off-the-cuff remark or joke, something where that witness lets down his or her guard, that's when you follow up with a pounce question. That's when you follow up with the question that may make or break your case. But if you have your head and nose buried in the outline, there is no rapport that's going to be established. So I would urge you, have sketchy notes. Don't rely as a crutch on an outline. It's not going to work.
Please take a moment to write down lawline.com's second verification code. Lawline.com's second verification code is the word finance, all lowercase, F-I-N-A-N-C-E, finance.
Now, as far as today's world, when I started, and I don't want to date myself, but internet wasn't around. Now, where you have the advantage over me, if you're a younger lawyer, is that you can get on the internet, you can go on Google, you can do a search of every expert that may be called to testify at trial or whom you may want to depose. Under those particular circumstances, do the search. Find out as much as you can about the expert. Maybe the expert's license to practice medicine was revoked or suspended. Maybe it was a situation where the expert was sued for malpractice 5 or 6 times and the expert's carrier paid off 4 or 5 times. In other words, there's a host of information that the internet provides that you should make available to you before you even walk into the deposition. Knowledge is key, knowledge is power. And if you know about your expert, you maintain control over your expert. Now, very important fact to also keep in mind when you want to establish rapport that I mentioned a few minutes ago. At the beginning of the deposition, say to the expert, even if it's self-deprecating, juries enjoy that. Juries like to hear that. They don't want to feel intimidated. Start off in your list of instructions or ground rules. Say to the expert, you know, Dr. Smith, I may from time to time use a term of medicine inartfully. I may be using it incorrectly. There may be a better term. If that happens, I would ask that you simply correct me and tell me, say, Mr. Toll or James, this is what you really meant to ask in the context of what the term is. Perhaps I've used the wrong diagnosis. I've used the wrong medical term. Don't be afraid to appear ignorant. He's the one with the degrees in medicine, or she's the one with the degrees in engineering. You're not the engineer. You're not the medical doctor. Don't be afraid to show ignorance. It makes you human, and it gives you an out if you do make a mistake. Because under those circumstances, you're going to be able to establish control over the witness because you have that rapport. Now, this particular subject matter of expert deposition is something that I could talk about for hours and hours because there's a tremendous amount of nuance that goes into it. What I thought would be beneficial in knowing the basics of how to take a deposition is to actually look and read deposition testimony from depositions that, for example, I have taken of experts, both on the side of representing a plaintiff in a medical malpractice action and also in the side of representing manufacturers of medical devices, drugs, and the like. And included in the materials is an excerpt from my questioning of an expert physician that was hired by the defense to rebut the opinions of my expert in a failure to diagnose case. And rather than to actually read, for your purposes, the deposition testimony, you can read it. The only background that I would give so that the testimony will actually be very meaningful for you is a little bit about the case. This way, when you see the excerpt and you read it on the slides, you'll understand a little bit more about what we're talking about. Take a man, my client, he's about 6 feet, 1 inch tall, and he has continuing problems of flushing face. He is breaking or fracturing bones in his back, the vertebrae, without really doing strenuous activity. He used to be about a 240 burly, big guy. And he's got these problems now where his bones have become very, very brittle. He goes to his primary care physician. Primary care physician orders up a series of thyroid tests, blood work. He must have ordered them up 3 or 4 times, and each time he's getting the same results. And each time my client is going back to him with the same complaints. He ultimately ends up going from 6 feet 1 to 5 feet 4 inches tall. Why? Because 9 vertebrae in his back fractured. And each time the vertebrae fractured, he lost height. And the question ultimately boiled down to was not a failure to diagnose what turned out to be Cushing's syndrome or disease, and you could look that up, but it was a failure to order laboratory tests to be interpreted by a specialist, in this instance, an endocrinologist. And what I established from the defendant's expert through using a destructive type of examination, where I was looking to essentially blow the other side out of the water rather than a constructive deposition, was to establish that all this particular defendant physician would have had to do was to take these series of lab tests for which it was patently obvious he did not have a clue as to what he was reading, send them off to an endocrinologist, and the expert admitted the endocrinologist would have known exactly what the problem was and would have ordered further tests which would have ultimately led to the diagnosis of Cushing's disease. And instead of being 5 feet 4 inches tall and hunched over like the Hunchback of Notre Dame, he would have remained at 6 feet 1 inches tall. That's included in the submission. The last point that I want to raise is have fun. Now, you may be saying to yourself, toll's gone on for about an hour. I need to know court rules. I need to know background on experts. I have to worry whether or not my adversary is going to pull a fast one on me. I may even have to call the judge if it's a situation where we can't resolve the issue. It seems rather contentious. Have fun? What is he on? Well, the reality is that if you're cut out for being a trial lawyer, and you need to ask that of yourself at an early age, if this is what you want to do, there is no greater feeling in the world, other than hearing at the end of a case that the jury found in your client's favor, than to take an expert who walks into a room as if they are walking on water and they are God's gift to their creation, to their field. And at the end of the day, that expert is walking out hunched over and defeated. Now, ultimately, you may end up in a situation where the other side pulls that expert and gets somebody else. You know what? It's worth the risk. But have fun. Because in the law, there's a lot of times when fun and the law are not synonymous. But here's one where you can go out and have yourself a good time. And once you know the court rules, once you know the evidence rules, and once you've done enough of these depositions, you're going to find yourself having fun. If you have any additional questions, I can be reached either through my website at www.toll.lawfirm.com or through my email address, which is toll@tolllawfirm.com. And again, as a certified civil trial attorney, I've handled hundreds, if not thousands, of these kinds of cases, and I would be more than happy to share what I've learned through trial and error, literally, and sometimes more painfully than others. But I can tell you, as I stand here today, that you can make a difference to your client, which is ultimately, when you've been sworn in as an attorney, that's who you owe your allegiance to. You can make a difference by being the best lawyer you possibly can be. Thank you.